Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. Welcome to the new subscribers and welcome back to all of our listeners that are so devoted to this podcast. I appreciate you so much. If you are here, you know that I've covered the Darlie Routier trial transcripts from the very beginning. The mother who in 1997 was accused and convicted of murdering her two children in Rowlett, Texas. If you're brand new here and want to start from the very beginning, you'll find all of the trial transcripts in their own playlist on YouTube. Now, at this point, the actual trial testimony is over. Her sentence has been handed down, and now we're moving on to the appeals process. So this is the post-trial. After this, we'll actually hear the writ of habeas corpus, the statements from the writ, both from the prosecution and the defense, and some motions for DNA testing, and then a few more trial-related stories to kind of close it out. And I'll do my best to give as much of a recent update as I can. Now, currently, I have the 24th of September-ish set as the day that we get back to the true crime episodes. As I mentioned before, many of you have asked me to cover other trials. I am looking into those. And as soon as I do have something decided, I'll definitely let you know. Now, with that said, if you've listened to the prior episode, this is not something new. If you have not, this episode is going to be a little bit different than the rest of the actual trial episodes. Normally, I would read the entire thing through, but after I started to read the appeals document, it doesn't really make for good listening because it's filled with a bunch of legalese and references to other cases and doesn't really offer a whole lot of explanation. So in this episode, you'll hear direct from the document. And then after each segment in the appeal, I'll give you a quick recap in more of an everyday language kind of style. And in the show notes, I will also have a direct link to the document if you care to read through it yourself. Now, this episode covers points of error number 2 and number 3 in Darlie's direct appeal, and this is dated July 23rd, 2001, and it was submitted by her appeals attorney, J. Stephen Cooper. Now, this point of error focuses mainly on the errors in the trial transcripts. But before we get started, it's important to understand the background regarding these trial transcript errors, because if you weren't aware, the transcriptionist for the trial later had her certification as a transcriptionist removed because of the errors in this document for Darlie's trial. So before I get to this point of error number 2 and number 3, let's talk first about what happened in the transcriptionist's hearing, because that will make these points of error more understandable. Okay, so what happened is in June of 1999, the court reporter for Darlie's case had a disciplinary hearing. And the way that this came about was because when Darlie's defense team was reviewing the transcript in order to prepare her appeal, they found significant problems like omissions and inaccuracies. There was a delay in the completion of the transcript, and the work was just really not up to par. What happened was this was brought to the attention of the Texas Court of Criminal Appeals, who then ordered a disciplinary hearing to investigate Halsey, that was her last name, and her quality of work. So in her hearing, this is actually what happened. First, let's talk about the audio tapes of the trial. Now, Halsey, the court reporter, first claimed that there were no usable audio tapes of the trial proceedings, specifically for the evidentiary and sentencing portions. Now, the sentencing portion, that's pretty self-explanatory, but I had to be sure exactly what the evidentiary portion was referring to. And it's essentially everything that happens in front of the jury. It doesn't include pre-trial motions or jury selection. Now, Halsey testified that these audio tapes were not usable. She said she had checked a couple of the tapes. She only heard static, and she said it could be because the battery failed in the microphone. Here's the thing, though. On October 30th of 1998, Halsey testified under oath that there were no audio tapes for the trial portion, only voir dire. In November of 1998, Halsey learned from her daughter, who is a scopist, and I had to look this up, didn't know what a scopist was. This is someone who works with court reporters to help make good transcripts. And according to her daughter, there were actually audio tapes of the entire trial. On November 12th of 1998, Halsey told Judge Francis that there were no usable audio tapes, but then later that same day admitted that there were. Now, these tapes were found in a storage unit in Plano, Texas. Halsey claimed she didn't know that they were there and that her husband had moved them without her knowing about it. There was a separate court reporter hired to review these tapes and Halsey's transcriptions. Sorry. Her name was Susan Simmons, and she went over the tapes. She also found them all usable with no static, and she could hear the voices clearly. Simmons then used these tapes along with the stenographic notes and computer disks from Halsey to make a corrected version of the transcript. Now, Simmons, she later said that she had found over 18,000 errors in the transcript and even called this figure a quote, conservative estimate. These errors were found in around 6,000 pages of transcripts. The types of errors that she found were typos, identification of the wrong speakers, for instance, identifying a judge as making a statement when it was actually a witness, words that weren't even included that were actually said in the trial, incorrect words, misspellings, major errors, such as transcribing like the word cussing, using that as the word instead of what was really said, which was kissing. Some words were used out of context, which suggested that they were transcribed based on sound rather than meaning. And Simmons, this new transcriptionist that reviewed all these, also found that there were no portions of the trial that were not covered by errors. They appeared throughout the entire transcript. It took Simmons 4 months to review and correct the errors. Simmons would later say that she didn't believe that the original transcript was even certifiable. Now, other items in Halsey's hearing were in regard to her billing practices. And Halsey had charged around $63,000 for the entire transcript. She included a full index of every volume of the transcript and charged evidently $425 per page for each index, even though it was essentially the same index in each volume. Evidently, there were also lots of pages with significant blank spaces or extremely wide margins that she would charge for these pages, the same amount for these pages. Halsey, I guess, also said that she was going to charge $3.50 per page, but later increased it to $4 or $4.25 per page. Now, Susan Simmons, on the other hand, the one who corrected the entire thing and took 4 months, charged $32,000 for that work. So about half as much as Halsey had. Halsey also claimed that during the time that she was transcribing Darlie's trial, she had marital problems. Evidently, her husband was having an affair. He had left her on July 10th, 1998. They had been married for 17 years. And at the time of her disciplinary hearing, when they did all of this about the transcript, she was going through a divorce. Her father evidently had been diagnosed with an illness, and she had been present when he had a medical emergency. He passed away on December 3rd, 1997, during the trial proceedings. And this happened evidently right after the voir dire and before the main trial actually began in January. Halsey, also mentioned attempting and was undergoing counseling. And she was meeting with the therapist quite often before July 1998, when the trial was moved to Kerrville. When this change of venue was announced, she did not want to go. And she said that because of this change of venue, she had to change recording equipment between the voir dire and the main trial, which might have led to some confusion about the audio recordings. She also said that she was quote unquote terrified of Judge Francis She said that she was terrified of this judge and his temper, and she had felt intense pressure to complete this transcript really, really fast. Halsey, she after this hearing, she had her certification revoked. She can no longer work as a court reporter in the state of Texas. She was also fined and evidently faced a lawsuit. I don't know if that was ever completed, but from Darlie's defense team stating that the poor quality of the transcript had compromised Darlie's ability to receive a fair appeal. Additionally, before we begin this information, you're going to hear a lot about the date of October 21st, 1996. Now, this was covered in the first episode of the appeal, and this was the date of jury selection as well as the day that Douglas Mulder, Darlie's eventual attorney throughout the trial, filed a motion to become her official attorney. However, he was still representing Darlie Key, Darlie's mom, and Darren at the time, which meant that there was a conflict of interest. Now, at the time, the judge had asked about a conflict of interest, but evidently he only asked about this conflict regarding Darlie's mom, Darlie Key, and he didn't ask about Darren. At least this is what I understand. But this portion of the transcript has gone missing or was lost or something to that effect. So that is why you'll hear a lot of references in these points of error to the date of October 21st. So now that we have all of the background of why this information was included in these points of error number 2 and number 3 inside the appeal, let's get on with those points of error which deal with that topic. Point of error number 2. Appellant's conviction must be reversed because a significant part of the reporter's record necessary to the appeal was lost or destroyed through no fault of her own. And it goes on to say, the reporter's record of the proceedings conducted on the morning of October 21st, 1996 was lost or destroyed because the trial court found that the original stenographic record was inaccurate and a corrected record cannot be certified. The missing part of the record is significant and necessary to the appeal of appellant's claims regarding the conflict of interest and the court's preliminary instructions to the venire. The original reporter's record in this case was prepared, certified, and filed by the official reporter who attended the trial, Sandra Halsey. Halsey testified that she was present at all of the pretrial hearings in this case. Judge Robert Francis made a finding of the fact that Halsey's entire record had to be replaced with a new record because it did not conform to what happened at the trial that the former judge, Mark Toll, presided over. Another court reporter, Susan Simmons, was appointed to prepare, certify, and file a new reporter's record. Simmons created her record by systematically comparing the hard copy of the Halsey record with the unauthenticated audio tapes. When Simmons found an error in the hard copy as compared against what she heard on the audio tape, she made a correction. Simmons acknowledged this process as being an quote-unquote audio edit of the Halsey record. Simmons had the paper stenographic notes that Halsey turned over to the court, but Simmons only used the notes to assist her in identifying voices on the tapes or at portions of the tape where she was quote-unquote unsure of, because she could not certify that they were a true and correct transcription of what happened at the trial. Halsey's certificates were not included in the new record that Simmons filed. Simmons did not produce a certified reporter's record of the proceedings on the morning of October 21st, 1996. Simmons found discrepancies between the paper stenographic notes of the proceedings that Halsey surrendered and the official hard copy of that part of Halsey's record. In Simmons' opinion, Halsey must have used an audio tape to edit her stenographic notes of the proceedings and filed a hard copy of the edited record. However, Halsey's attorney informed the trial court that no audio tape for this portion of the proceedings had been located. Simmons said there, quote-unquote, did not appear to be any gaps in the stenographic notes of the proceedings on the morning of October 21st. However, she would not certify that Halsey's notes were a true and correct transcription of what happened in court without being able to listen to an audio tape. Halsey had never authenticated any of the stenographer's notes used by Simmons, and there is no evidence in this record that the notes Simmons used to prepare the uncertified morning session of October 21st, 1996 are the same notes, if any, that Halsey typed contemporaneously therewith. Simmons included a 54-page uncertified English translation of Halsey's stenographic notes of the proceedings on the morning of October 21st, 1996 in Volume 10 of the new record that she prepared. Simmons expressly stated in her certificate for Volume 10 that it did not apply to the first 54 pages therein. The uncertified pages in Volume 10 of the new record contain a hearing on the motion to substitute counsel and the court's preliminary instructions to the veneer. The docket sheet for October 21st, 1996 confirmed that those events occurred on that date. Appellant filed written objections to the inclusion of the 54-page uncertified record of the proceedings on the morning of October 21st, 1996, in Volume 10 of the new record and requested a hearing on the matter. Appellant alleged that this part of the reporter's record was lost or destroyed because it could not be certified. She maintained that the missing part of the record was necessary to appeal her attorney conflict of interest claim and any error in the preliminary instructions to the veneer. She also objected that the uncertified part of the record was inaccurate because it did not contain a hearing to determine whether lead counsel Doug Mulder had a conflict of interest as a result of his representation of Darlie Routier. Judge Francis adopted Simmons' testimony that the English translation of Halsey's stenographic notes of the proceedings on the morning of October 21st, 1996, could not be certified, but he refused to order Simmons to remove the 54 uncertified pages from the new record or conduct a hearing to determine whether that part of the record was lost, destroyed, or inaccurate. Okay, so just based on this little piece of information, let's try and do a really quick recap. In essence, what they're saying is that a significant part of the court reporter's record from October 21st, 1996 was lost or destroyed, which is absolutely necessary for the appeal. And as we already know, the original court reporter, Halsey, she had prepared a record, but it was found to be inaccurate by the judge in a trial and everything else, as we mentioned at the very beginning of this or at the intro in this episode. The reporter that was assigned to kind of redo everything, Simmons, she couldn't certify this record for the morning of October 21st, just simply due to the lack of an audio tape for that session. But Simmons did have access to, I guess, some of the actual transcribed notes and created an uncertified 54-page translation of Halsey's notes for that morning of October 21st of 1996. And this was included in a new record. In this appeal, the attorney is objecting to this inclusion of this uncertified record, arguing that it was inaccurate and it completely missed this hearing about Doug Mulder and his potential conflict of interest. Now, the judge at the time, he did acknowledge that this portion of the record couldn't actually be certified, but he refused to remove it or even hold a hearing about whether it was lost or destroyed or inaccurate. And so Darlie's attorneys are arguing that this missing part or this uncertified part is crucial for appealing claims about this attorney conflict of interest. And within this section, there are actually a couple of citations. And I mentioned this in the previous episode or in the first episode of the appeal, where sometimes I don't mention these because they're just more record keeping kind of citations. But some of them actually contain information. And in citation number 15, it says, quote, "The trial court discharged Halsey from her official duties after she gave false testimony to conceal the existence of audio tapes of the trial and invoked her Fifth Amendment right against self-incrimination when she was questioned about it at a hearing on the appellant's motion to correct the record." And the trial court made a finding that Halsey is unable to certify the reporter's record in the case as true and correct, unquote. And this is because she had her license removed. The citation number 16 is, quote, the audio tapes were taken into the court's possession and eventually turned over to Simmons without any evidence of authentication, unquote. Citation 17 says, quote, the trial court scheduled a hearing for September 8th, 2000 on appellant's objections to the new record, but the hearing was canceled by virtue of the issuance of an order at 3:15 p.m. on September 7th, so the day before, which referred the entire matter back to this court. Mulder and Halsey, among others, were subpoenaed to testify at the hearing, and the trial court refused to allow the appellant to make an offer of proof after it was canceled, unquote. And I had to go back and figure, okay, what is an offer of proof, right? So evidently an offer of proof is a formal statement of evidence for the record. Next, let's move on to arguments and authorities, and we are still under the point of error number 2. And this says, Texas Appeals 34.6 F provides that an appellant is entitled to a new trial when a significant part of the reporter's record necessary to the appeal was lost or destroyed through no fault of her own. The appellant has the burden of proving that 1, there was a court proceeding in her case that does not appear in the reporter's record. 2, a stenographic record of the proceeding was made by the official reporter. 3, that part of the record was lost or destroyed. And 4, the appellant was not responsible for it. If a significant part of the reporter's record necessary to decide the appeal was lost or destroyed through no fault of the appellant, no further showing of harm is required for her to obtain a new trial. The loss or destruction of the record of a pretrial hearing, which was significant and necessary to the appeal, cannot be remedied by ordering nunc pro tunc hearing. Next, we move on to the section that says the record of a court proceeding was lost or destroyed. Appellant proved that there was a stenographic record of a court proceeding on the morning of October 21st, 1996, because the official court reporter, Sandra Halsey, testified that she was present at all of the pretrial hearings. And purportedly, all the steno notes had been turned over, including the notes that she allegedly took on that date. The reporter's record of the proceedings on the morning of October 21st, 1996, is lost as a matter of law, even if all of Halsey's paper stenographic notes of the proceedings were preserved, because that part of the record is not and cannot be certified. The official court reporter who filed a stenographic record must certify in writing that it is a true and correct transcription of the proceedings in the courtroom. Simmons did not certify a reporter's record of the proceedings on the morning of October 21st, 1996, and she will not do so because Halsey's stenographic notes are not trustworthy and the audio tape of the proceedings was lost or destroyed. Halsey's original certified record of the proceedings on the morning of October 21st, 1996 cannot be used to decide the appeal because Judge Francis found that Halsey's record did not conform to what happened at the trial. Halsey's certificate created a presumption that her record was a true and correct transcript of the proceedings, but the presumption of regularity was overcome with evidence. Halsey cannot certify a corrected stenographic record of the proceedings on the morning of October 21st, 1996, because she lost her court reporter's license, and Judge Francis would not trust her to perform any official duty if her license was restored. Furthermore, the uncontradicted statements of Halsey, the trial judge, 2 prosecutors, a defense attorney, and appellant on November 12th and November 18th, 1996, proved that Halsey must have made a stenographic record of the hearing about the conflict, which resulted from Mulder's representation of Darlie Routier on the morning of October 21st, 1996, which does not appear in the stenographic notes of the proceedings that Simmons translated. The undisputed unsworn statement of a single defense attorney, one prosecutor, the trial judge, or Halsey would have been sufficient to establish that there was such a hearing, even if it did not appear in a certified record. The undisputed recollections of the court and all of its officers are more trustworthy than the uncertified English translation of Halsey's stenographic notes, and it is inconceivable that they were all mistaken. The prosecutor who cautiously filed a written motion for a second hearing about the conflict arising from Mulder's representation of Darren Routier on November 12th, 1996, to avoid the risk of a reversible error, certainly did not create such an error by neglecting to follow through on his motion. It is much more likely that the prosecutor decided that it was not necessary to have another hearing after he requested it because he concluded that Appellant made a valid prospective waiver of any conflict arising from Mulder's representation of her husband at the first hearing on October 21st, 1996. Simmons' failure to notice a gap in Halsey's unauthenticated paper stenographic notes of the proceedings on the morning of October 21st, 1996, does not prove that Halsey did not make a stenographic record of a hearing on that date about the conflict that resulted from Mulder's representation of Darren Routier. The missing part of Halsey's stenographic record could be a couple of lines long if it was similar to the very brief discussion of Mulder's representation of Darlie Key. Halsey could have typed that small part of the record on a separate strip of paper that was lost or destroyed. The missing conflict hearing could have been artfully removed from the beginning or end of the paper strip that Simmons translated. Halsey's stenographic machine could have malfunctioned for a few moments when she typed that part of the record. The trial court's entry on the docket sheet for October 21st, 1996, is evidence that Halsey's paper stenographic notes did not reflect all of the proceedings that were conducted that morning. Facts set forth in a docket entry are routinely accepted as evidence of the occurrence or absence of an event, unless some statutory mandate provides to the contrary. The docket sheet states that testimony and evidence was introduced at the hearing on Mulder's motion to substitute himself as lead counsel, but the English translation of Halsey's stenographic notes only shows that there was an unsworn colloquy about that motion. In accordance with the above authorities, no conclusion can be drawn from the fact that the docket sheet did not mention a hearing about a conflict of interest on October 21st, 1996, because there is evidence to the contrary. Halsey's uncertified stenographic notes show that there was a hearing about the conflict arising from Mulder's representation of Darlie Key on the morning of October 21st, 1996, that was not mentioned on the docket sheet. This is because it is wholly different to assert that a docket entry is evidence something did occur compared to a claim that the absence of a docket entry reflects an event did not occur where the quote-unquote record reflects otherwise. It is quite possible that the trial court did not mention that conflict or the conflict arising from Mulder's representation of Darren Routier on the docket sheet because the trial court considered the discussion of both conflicts to be part of the hearing on Mulder's motion to substitute himself as appellant's counsel of record. Or the court simply could have failed to make an entry due to oversight. There is, after all, no legal requirement that such a docket entry be made. Extrinsic evidence cannot be used to reconstruct the reporter's record of the proceedings on the morning of October 21st, 1996, that was lost or destroyed, even if the trial court found that the reconstructed record conformed to what happened at the trial. It would also be impossible to use that procedure here because the judge who presided over the trial is retired. Okay, so first let's start off with a recap of the argument and authorities. Essentially, the Texas Rules of Appellate Procedure, which is that Rule 34.6 parentheses F, it says that a person appealing a court decision, so in other words, this is Darlie, can get a new trial if an important part of the court record needed for their appeal is lost or destroyed, as long as it wasn't their fault. And in order to qualify for this, the appellant, Darlie, needs to prove a few things. That there was a court proceeding in their case that was missing from the official record, that the court reporter made a written record of that proceeding, that was lost or destroyed, and that Darlie was not responsible for that. If these conditions are met and this missing part is significant for deciding the appeal, the appellant, Darlie, doesn't need to prove anything else about how this hurts their case. They're automatically entitled to a new trial. And the argument is that this rule applies even to records of pretrial hearings if they're important for the appeal. Now, in such cases, and um, when you heard that term, this nunc pro tunc hearing, I wasn't sure what that was. It's in essence, it's that the court can't fix the problem just by holding a new hearing to recreate what happened, essentially. So that's the really brief recap of the arguments and authorities section. And next, we move on to a recap of the portion that says the recording of a court proceeding was lost or destroyed. So this portion of the appeal says that, or argues that a part of this court record from this October 21st date, again with Mulder, all of a sudden wanting to be Darlie's attorney, that this part of the court record was lost or destroyed, which is significant for the appellant's case. And the main points are, there was this court proceeding on the morning of October 21st. And the official court reporter, Sandra Halsey, she was present and she took notes. The record from that morning is considered lost as a matter of law because it cannot be properly certified, and an uncertified record cannot be used in an appeal. The court reporter that was brought in to kind of redo these things, Simmons, she can't certify the record because she doesn't believe that Halsey's notes are trustworthy. And an audio tape of the proceedings was lost and destroyed. Halsey, as we know, lost her court reporter's license and is not trusted to perform official duties, so she can't go back and certify this stuff. There's evidence that a hearing about a conflict of interest, this one, and this is the October 21st one about Mulder and representing Darren. There's evidence that this took place that morning, but it doesn't appear in the translated stenographic notes. And multiple people, including the judge, the attorneys, and Darlie, confirmed that this hearing took place, which is considered strong evidence, even if it's not in the official record. And next, we move on to the missing part of the reporter's record is significant and necessary to the appeal. And it starts with the attorney conflict of interest claim. A reporter's record of the proceedings on the morning of October 21st, 1996, is essential to determine whether appellant is entitled to relief on the attorney conflict of interest claim that she raised in point of error, number 1, if the incomplete record does not show that this point of error must be sustained. There are 2 questions that the court must answer to decide that claim. 1, did the trial court fail to conduct an adequate hearing about Mulder's conflict? 2, did Mulder have an actual conflict or a potential conflict? A record of the proceedings on the morning of October 21st could contain the answers to both of those questions. There was no hearing about the conflict that existed because of Mulder's representation of Darlie Routier if the hearing did not occur on the morning of October 21st, 1996, because it did not appear in any other part of the record. If a hearing about that conflict was conducted on the morning of October 21st, the record of it is necessary to decide whether appellant made a valid prospective knowing and intelligent waiver of her right to raise the issue again if new evidence of the conflict emerged. A record of conflict hearing on the morning of October 21st, 1996, could have shown that Mulder had an actual conflict instead of a potential conflict because Mulder's representation of Darlie Routier was more closely related to appellant's case than the incomplete record presently suggests. A record of the conflict hearing on the morning of October 21st, 1996 may also have revealed that Mulder was retained by Darlie Key to act as a legal advisor to the entire family because she was concerned that appellant's court-appointed lawyers were planning a defense that pitted her daughter and son-in-law against each other. That third-party fee arrangement would have made it impossible for Mulder to give appellant conflict-free advice about whether to adopt a defense that accused Darren, even if his representation of Darren at the show cause hearing only created a potential conflict. Any hypothesis about what happened at the conflict hearing would necessarily be speculative, but it is not possible to conclude that there was no reversible error without a record of that proceeding. A certified reporter's record of the proceedings on the morning of October 21st, 1996, is also significant and necessary to the appeal because the prospective jurors received preliminary instructions in that part of the record, which may have been erroneous. Appellant's conviction must be reversed and a new trial must be ordered because that significant part of the record and the hearing about Mulder's conflict was lost or destroyed through no fault of her own. Okay, so let's recap what we've just heard about the missing part of the reporter's record, etc. So I know it really seems like it's kind of rehashing the same things, right? But there's always these little details in each section that seem to be just a tiny bit different. So here for this particular section, it says that the missing part of this court record on this morning of October 21st is crucial because of the attorney conflict of interest claim. You need the record to determine if the court properly addressed this conflict of interest that included Mulder. This record could show whether Darlie made a valid waiver of her right to raise this issue later. It could possibly show if Mulder had an actual conflict rather than just a potential one. And it could also show if Mulder was hired to advise the entire family, which would make it impossible for him to give conflict-free advice to Darlie. And again, this section kind of concludes that, because this part of the record was lost or destroyed and it was not Darlie's fault or her attorney's fault that this happened, her conviction should either be reversed and a new trial should be ordered. Point of error number 3. Appellant is entitled to a new trial because the reporter's record does not conform to the requirements of Texas 34.6 and the defect cannot be corrected. And the statement of facts is appellant is entitled to a new trial because the reporter's record does not and cannot be made to conform to the requirements of Texas 34.6. And then it gives the rule number, provides that the reporter's record must be a certified verbatim transcription of the stenographic notes of the court reporter who attended the trial. The reporter's record in this case is a transcription of unauthenticated, uncertified audio tape recordings prepared by a court reporter who had no personal knowledge of the trial or the integrity of the tapes. The stenographic notes of the court reporter who attended the trial cannot be accurately transcribed and certified by any reporter because the trial court found that the notes did not conform to what happened in the courtroom. It would be impossible to correct the original stenographic record by settling the disputes about it with extrinsic evidence because it may be judicially noticed that the judge who presided over the trial is retired and the court reporter who typed the stenographic record is no longer a certified reporter. Further, appellant is entitled to a verbatim transcription, quote, unblemished by human interpretation, unquote. The original reporter's record in this case was prepared, certified, and filed by the official court reporter, Sandra Halsey, in April 1998, only after this court held her in contempt for disobeying several filing deadlines. The first dispute about the accuracy of Halsey's record was raised in appellant's motion to correct/clarify reporter's record dated October 11th, 1998. Appellant alleged that there were substantive discrepancies between the reporter's record, a part of Darlie Routier's testimony, and a transcript of the same part of his testimony in the clerk's record that was read back to the jurors during their deliberations. Appellant asked this court to remand the case pursuant to, in a Texas law, for the trial court to determine whether the record of that part of Darlie Routier's testimony was inaccurate. On October 14th, 1998, the court issued an order which stated, quote, "The dispute is submitted to the trial court for resolution. The trial court must ensure that the reporter's record is made to conform to what happened at trial." On October 30th, 1998, the trial court decided after a hearing that the accuracy of the entire reporter's record of the trial had to be reviewed to comply with this court's order. Halsey had testified that her stenographic notes of Appellant's trial were simultaneously typed on paper strips and computer edit disks that automatically translated the stenographic symbols into English. Halsey testified that she also made audio tape recordings, but, quote, "The only tapes that she had where the tape recorder was actually working were the ones from the jury voir dire," unquote. Halsey explained that the microphone on her tape recorder did not work during the remainder of the proceedings because it needed a battery. She claimed that she did not discover the problem until, quote, "after the trial was over," unquote. The trial court ordered Halsey to review her entire record to determine whether it was accurate and correct any mistakes that she found. The trial court also announced that it was going to appoint independent expert court reporters to compare the stenographic notes on Halsey's computer edit disks to the hard copy of her record, quote, "so that if necessary, independent testimony or evidence can be given as to the ability to certify as to the reporter's record," unquote. On November 4th, 1998, the trial court appointed 3 expert court reporters to review Halsey's record of both phases of the trial on the merits. And these 3 expert court reporters were Tommy Mullins, Judy Miller, and Jerry Calloway. And it goes on, and it says Halsey met with Miller, Calloway, and Mullins and told each of them that she had no audio tapes of the trial on the merits. However, on November 13th, 1998, the parties stipulated that Halsey told prosecutor Lindsay Roberts that, quote unquote, "there were audio tapes reflecting the occurrences of the guilt/innocence and punishment phases," unquote. According to the stipulation, Roberts accompanied Halsey to a storage facility in Plano, where he retrieved a box of audio tapes that were represented to him, quote, "as the audio tapes for the Routier trial," unquote. Halsey's daughter, Susan Crowley, was one of 2, quote unquote, scopists who helped Halsey edit her original stenographic record before she filed a hard copy of it. Crowley testified that Halsey gave her audio tapes of the guilt and penalty phases of the trial and the original stenographic record of those proceedings that Halsey typed on computer edit disks. Crowley used the audio tapes to make permanent changes in the English translation of the original stenographic record on the computer disks. Crowley never received any audio tapes of the voir dire or pretrial hearings because she did not participate in the preparation of the record of that part of the trial. Crowley looked at, quote unquote, some of the audio tapes that Halsey turned over to Roberts and testified that they were, quote unquote, similar to the tapes that she used to change the computer disks. Crowley did not say whether Halsey gave Roberts all of the audio tapes of the guilt and penalty phases of the trial, nor did she specifically identify the tapes displayed to her as being all the tapes she reviewed. When the state introduced the audio tapes that Roberts received from Halsey and the stipulation, counsel objected that Appellant did not agree that, quote, "these are in fact the tapes and that they're authentic," unquote. The prosecutor confirmed that he was not making any representation to the court about the authenticity of the audio tapes. The tapes were admitted into evidence with the understanding that the question of their authenticity would be, quote, "subject to further review," unquote. The trial court never ruled on that question. On December 9th, 1998, Halsey's lawyer produced 12 additional audio tape recordings to comply with a subpoena for all of her audio tapes of the trial. No sworn testimony about the identity or history of the tapes was ever introduced, and they were never authenticated. Okay, so let's just really, really quickly recap this first portion of the point of error number 3 that we've heard. They're still talking about the transcripts for the trial, and they're arguing that they are entitled to a new trial because the court reporter's record did not meet the legal requirements and it cannot be corrected. But there are some kind of interesting things that we learn here, right? We know that the original court record was prepared by Sandra Halsey, the official court reporter, in April of 1998. But she only did this after she was held in contempt of court for missing several deadlines for submitting this. In October of 1998, the appellant, so Darlie and her attorney, they first raised the point about the accuracy of the transcripts. And part of this was because there were, what I gather, significant differences between the reporter's record of part of Darren's testimony and a transcript of some of this same testimony in this record had been read back to the jurors during their deliberations. The appellant asked the Court of Criminal Appeals to send the case back to the trial court because they wanted the trial court to check if the record of Darren's testimony was even accurate. So on October 14th of 1998, the Court of Criminal Appeals, they agreed to this and they ordered the trial court to, resolve this dispute about the accuracy of the transcripts and make sure that the reporter's record matched what actually happened during the trial. So when we get into the review of the entire reporter's record, we've discovered that on October 30th of 1998, a trial court, as we know, ordered a review of the entire court record from this trial. And the court reporter, Halsey, evidently had said that the trial proceedings had been recorded in various ways, right? They were typed on paper strips. She used computer disks that automatically translated her shorthand into English and audio recordings. But evidently, these audio recordings only worked for a really small section, the jury selection portion. And Halsey said that the reason for this was because her audio recorder didn't work for most of the trial because of a dead battery, which she only discovered after the trial had ended. Which, sorry, I'll reserve my opinion for that. The court then ordered Halsey to review her entire record and fix any mistakes. And they also decided to bring in these independent court reporters, right? These independent experts. Their job was to compare Halsey's computer records with the printed version of her report. So on November 4th, the court then appointed these experts, this Tommy Mullins, Judy Miller, and Jerry Calloway, to review Halsey's record of both parts of the trial. So Halsey, when she met with these three people, she told them that she had no audio recordings of the main trial. But on November 13th of 1998, Halsey had told someone that there were audio recordings of both the guilt and innocence and punishment phases of the trial. So they go to a storage facility, and this is the one in Plano, Texas, where Halsey evidently pulled out a box of tapes and said, "Hey, these are from the trial." So Susan Crowley, who happens to be Halsey's daughter, she is a scopist. We've talked about what a scopist is before. She is the one who helped to edit this trial record. And she said that Halsey gave her these audio tapes of the main trial phases and the original stenographic record on computer disks. And Crowley, used these tapes to make changes to the computer record. She also looked at some of the tapes that were given to one of these three experts and said that they were similar to what she used, but she didn't confirm if all of the tapes were actually there. Then on December 9th of 1998, Halsey's lawyer produced 12 more audio recordings in response to a legal request for all of her trial recordings. So, yeah, this just gets more and more confusing, doesn't it? Next, we move on to the next subject in the direct appeal, and that is Halsey's invocation of her right against self-incrimination. The trial court relieved Halsey of her duties as the official court reporter in this case with the consent of both sides after she turned over the unauthenticated audio tape recordings. Counsel subsequently tried to question Halsey as a fact witness, but she invoked her right against self incrimination after she testified that she was present at all of the proceedings in Appellant's case, including the pretrial hearings. On November 13th, 1998, Miller, Calloway, and Mullins testified that they each reviewed Halsey's record of the part of Darren Routier's testimony that was read back to the jury and other selected parts of her record of the trial on the merits. Each expert compared the hard copy of those parts of the Halsey record to the stenographic symbols on Halsey's computer edit discs. Each expert testified that there were significant discrepancies between the hard copy of the record and the stenographic symbols on the discs. In the opinion of each expert, Halsey must have used audio tape recordings to make changes in the English translation of the stenographic record that she typed on the discs, printed a hard copy of the altered record, and filed it. Each expert court reporter recommended that the entire Halsey record should be reviewed by another reporter. Mullins specifically recommended that Halsey's stenographic notes and the unauthenticated audio tapes should both be compared to the hard copy of Halsey's record. And then in this appeal, we get into the trial court's order for a new court reporter to review Halsey's record of the guilt and punishment phases of the trial. And it goes on to say the trial court accepted the recommendations of its experts to appoint a new court reporter to review Halsey's record. The parties agreed that Susan Simmons should do the job. The trial court initially ordered Simmons orally and in writing to compare the hard copy of the Halsey record of the guilt and punishment phases of the trial with Halsey's paper stenographer's notes, her computer edit discs, and the tape recordings, quote, in compliance with standard industry practice, unquote. Make all corrections which she deemed necessary, produce a record, quotes, of everything that she has reviewed, unquote, and certify to the accuracy of a new record if possible. When the trial court orally announced that order, counsel objected that it was not legally permissible for Simmons to certify a new record. The trial court responded, quote, I imagine that will be an issue taken up with a different court than this one, unquote. On November 18th, 1998, Appellant filed in this court a motion to abate this appeal. This motion recited the developments in this case, which had so far occurred pursuant to the proceedings conducted under the authority of this court's order of October 14th, 1998. However, it was then apparent that the errors in the Halsey record went far beyond those cited in Appellant's earlier motion to correct/clarify, and that Sandra Halsey was refusing to participate in any correction of the record. In turn, the relief needed by Appellant to ensure an accurate appellate record went beyond that which this court granted in its October order. Appellant requested an abatement to give the trial court jurisdiction to take such steps as necessary to ensure an accurate reporter's record. This motion was denied, although this court did extend the original 30-day deadline for compliance with the October order. Okay, so we know that Halsey was removed as the official court reporter, right, for this case. Both sides agreed. She handed over these audio recordings or what have you. But then later, when the lawyers tried to question Halsey as a witness, she invoked her Fifth Amendment right. She only confirmed that she was present for all parts of the case, including pretrial hearings. So on November 13th, when these three expert court reporters, as Miller, Calloway, and Mullins, gave their findings, they said that they reviewed the parts of Halsey's record, including Darren's testimony that was eventually read back to the jury during deliberations. They compared the printed copy of Halsey's record to the shorthand symbols that she would create that were on those computer disks. And all three of these experts found significant differences between the printed record and the shorthand that were on the computer disks. And they believed that Halsey, she must have used audio recordings to make changes to the English translation of her shorthand record on these disks. And then she printed and filed this altered version. So evidently Halsey, what, has these audio recordings like in her possession and she was able to do this? That's the way that I read it. Additionally, all three of these experts recommended that Halsey's entire record should be reviewed by another court reporter, and that's when this Simmons was brought in on the case. And the trial court initially, they wanted Simmons to, compare the printed copy of Halsey's record for the guilt and the punishment phases. They wanted this compared with her paper notes, the computer disks, the any tape recordings, make any necessary corrections, produce a record of everything that she reviewed, and if possible, certify this as a new and accurate record. Now, of course, when this was brought up, the defense is like, hey, she's not legally allowed to certify a new record. And so on November 18th, there was a motion filed to pause the appeal because, they're still working with this testimony, right? The court reporter's transcript, sorry, not testimony, but transcript. And the reason for this was that, they had described what happened so far under the court's order on October 14th. They noted that the errors in Halsey's record were more extensive than they originally thought. They mentioned that Sandra Halsey herself was refusing to help correct the record, and they asked for this time to allow the trial court to take the necessary steps so that they could get an accurate record. Now, this motion was denied, but the court, they did extend the deadline for complying with the October order. So that's where we are right now. Let's move on. And next, they go on to the hearing to determine whether Simmons could certify a new record of the guilt and punishment phases of the trial. So on April 1st, 1999, the trial court conducted a hearing, which the trial court described as a, quote, a continuation of hearings which began after the October 14th of 1998, pursuant to an order issued to this court by the Court of Criminal Appeals on that date, unquote. The trial court called Simmons and Tommy Mullins to testify as the court's witnesses. The attorneys were only allowed to propose questions for them in writing. Appellant had filed a written objection that this procedure violated her constitutional rights to due process, effective assistance of counsel, and confrontation. The trial court overruled these objections and explained that Appellant would not be permitted to directly question the witnesses, quote, because this is a fact-finding hearing, and I'm doing this at the direction of the Court of Criminal Appeals, unquote. It is unclear whether the court was referring to this court's direction to conduct this hearing or to the decision not to allow Appellant to question these witnesses. While conducting one or more hearings seems a logical extension of this court's order of October 14th, 1998, Appellant is unaware of any court order of this court not to permit counsel to question witnesses at any such hearings. Simmons testified that she created her own new record of the guilt and punishment phases of the trial, as well as a red-lined copy of the Halsey record that reflected all of the changes that she made. Simmons had Halsey's original stenographic notes on paper strips, but she did not produce an English translation of them. She did not know whether Halsey changed the original English translation of her stenographic notes on her computer disks before she surrendered the disks. The procedure that Simmons used to create her new record was different than the procedure that a court reporter ordinarily uses to create a hard copy of the record from the original stenographic notes that were simultaneously typed during the trial on paper strips and the computer disks, where the reporter's symbols are automatically translated into English on a split screen. Simmons testified that the first step of the standard procedure is to load the original stenographic record that the reporter typed on the computer edit disks to a split computer screen that displays the stenographic symbols and an English translation of them side by side. The reporter listens to an audio tape as she reads the English translation on the computer screen and makes any necessary changes in the English translation. The edited English translation on the screen is next downloaded onto new computer disks, proofread, and saved again on the new disk. A hard copy of the proofread English translation on the new disks is printed out and filed with the court. Instead of this normal procedure, Simmons started by systematically comparing the hard copy of the Halsey record with the unauthenticated audio tapes instead of comparing the tapes to the English translation of the stenographic record on Halsey's computer disks, which Halsey could have changed. When Simmons found a mistake in the hard copy of the Halsey record, she made a handwritten change on it in red ink. She described this process as an audio edit of the Halsey record. Simmons had Halsey's original paper stenographic notes beside her when she used the unauthenticated audio tapes to change the hard copy of the Halsey record, but she did not systematically compare the notes to those materials. Simmons testified that she would only flip to the paper stenographic notes that Halsey typed if she came to a part of the hard copy of the Halsey record that she was unsure of when she compared it to the audio tape. Simmons explained that she also consulted the paper notes when she had a question about the identity of a speaker. She never indicated that she referred to the paper notes for any other purpose. Tommy Mullins testified that it was common practice for a court reporter to use audio tapes for quote-unquote editing purposes to create a record that is different in some respects from the original stenographic notes. Neither Mullins nor Simmons nor any other witness indicated what the usual level of discrepancy was or whether Halsey's record exceeded it. Both Mullins and Simmons agreed in response to the trial court's leading questions that it is normal for a new record and the original stenographic record not to match exactly. Simmons testified that the unauthenticated audio tapes of the guilt and punishment phases of the trial were complete, audible, and had no discernible gaps when she listened to them. But she did not offer an expert opinion about whether any of the tapes were edited or erased before she received them. She acknowledged that her new record could be tainted if there was a defect in the tapes that she could not detect by playing them. She claimed that she could certify that her record was a true and correct transcription of what happened at the guilt and penalty phases of the trial, even though she had no personal knowledge of the proceedings, the identity of the audio tapes, or their integrity. Appellant filed and presented a written motion to make a bill of exception about some of the questions that she was not allowed to ask Simmons. Appellant's bill stated that she would have asked Simmons whether she compared each line of the Halsey record to Halsey's original stenographic notes, and if not, why. Her bill stated that she also would have asked Simmons to describe exactly how she used Halsey's original stenographic notes to compare her record. The trial court did not ask Simmons those specific questions. Next, we have the appellant's request for an opportunity to call witnesses to testify about the new record after she reviewed it. And it's a really short paragraph. Appellant's attorneys did not receive a copy of Simmons' new 28-volume record of the guilt and punishment phases until after Simmons finished her testimony. Counsel informed the trial court that he might want to call witnesses to testify about the new record after he reviewed it, and the trial court responded, quote, "We'll cross that bridge when we get to it," unquote. The next section is appellant's objection to filing the new reporter's record before she had an opportunity to review that record and compare it to Halsey's original stenographic notes. Appellant filed written objections to filing a new or corrected copy of the reporter's record and presented them to the trial court for a ruling at the beginning of the April 1st, 1999 hearing. Appellant asserted in this pleading that she was unwilling to agree to the filing of the Simmons record without reading it, because Simmons used the uncertified, unauthenticated audio tapes to create a new record instead of transcribing Halsey's stenographic notes. Appellant further stated that she was unable to prove that there were specific discrepancies between the Simmons record and Halsey's steno notes because the trial court did not give her attorneys an opportunity to compare those materials. Appellant also asked the trial court to order Simmons to systematically compare Halsey's stenographic notes to her record, the Halsey record, and the audio tapes, or give her attorneys a reasonable opportunity to do so before a new record of the guilt and penalty phases was filed with this court. The trial court promised to address those issues with a written order. Okay, so here's our brief recap so far from what we've learned. On April 1st, 1999, the trial court held a hearing that had Susan Simmons and Tommy Mullins, the ones who had been requested to redo the transcripts for the trial, or at least the portions that they had access to. And they called them as witnesses, and lawyers, they could only propose written questions, which the appellant objected to as a violation of her constitutional right, and the court overruled that objection. Simmons, the one who redid the transcripts, she had created a new record of the trial's guilt and punishment phases. And she also gave a marked up copy of Halsey's original record, but it showed Simmons' changes on this record. This is that one with the red ink. But Simmons did her thing a little bit differently. She compared Halsey's printed record with the unauthenticated audio tapes rather than just using Halsey's computer disks. And she made these handwritten changes in red ink when she found the mistakes. And she then only referred to Halsey's original paper notes when she was unsure about something in the printed record or to identify who was talking. Tommy Mullins, another one of the professional transcriptionists, testified that it is common for court reporters to use audio tapes for editing purposes, which can result in differences from the original notes that they took. Simmons also said that the audio tapes seemed to be complete and audible, but she did admit that her new record that she created could be compromised if the tapes had defects that she was not aware of. We then learned that Darlie's attorneys, they did not receive a copy of Simmons' new 28-volume record of the guilt and punishment phases until after Simmons had finished testifying. And additionally, the appellant, Darlie, and her attorneys filed written objections to filing a new or corrected copy of the reporter's record that and these were presented at the April 1st, 1999 hearing. The objections included the unwillingness to agree to filing Simmons' record without reading it first, because Simmons used uncertified, unauthenticated audio tapes to create a new record instead of transcribing the stenographic notes. And the appellant then requested that the court either order Simmons to systematically compare Halsey's notes to her new record, the original Halsey record, and the audio tapes, or give the attorneys a reasonable opportunity to do this comparison before a new record of the guilt and penalty phases was filed with the court. And the trial court promised to address these issues with a written order. So let's move on now to the next section. The next section is the trial court's order to replace the original reporter's record of the guilt and penalty phases of the trial and give appellant an opportunity to object to the new record after she reviewed it. On April 14th, 1999, the trial court signed an order which stated that the Halsey record of the guilt and punishment phases of the trial should be replaced by the Simmons record because Halsey's record of those proceedings did not conform to what happened at the trial. The trial court believed Simmons' testimony that her record of the proceedings was true and correct and arranged for her new record to be filed with this court before appellant had an opportunity to review it. The trial court did not independently review the new record before it made that finding. The trial court's April 14th, 1999 order gave appellant 120 days to read the 28 new volumes that she received that day and file any objections to the new record or motions for further relief because the interests of justice required it. Next section is the hearing to determine whether Simmons could certify a new record of the voir dire and other pretrial proceedings. On April 26, 1999, this court granted appellant's motion to order the trial court to review Halsey's record of the voir dire and pretrial hearings to determine whether it conformed to what happened at the trial. On October 14, 1999, the trial court called Simmons as its witness and questioned her about her record of those proceedings again without allowing the attorneys to do so. Appellant renewed her objections to that procedure, and they were overruled. Simmons testified that she used the same materials and procedures to produce a new certified record of the voir dire and pretrial hearings that she used to prepare a new record of the guilt and penalty phases of the trial. The next section is the trial court's order to replace the original reporter's record of the voir dire and other pretrial proceedings and give appellant an opportunity to object to the new record after she reviewed it. On November 5th, 1999, the trial court issued an order which stated that Halsey's record of the voir dire and pretrial hearings should be replaced by the Simmons record of those proceedings because the Halsey record did not conform to what happened at the trial. The trial court believed Simmons' testimony that her record of those proceedings were true and correct, but it gave appellant an additional 120 days to file any objections that she had to the Simmons record or motions for further relief. The trial court instructed appellant to file a separate motion to request a hearing on her objections to the Simmons record that set forth in detail why a hearing is necessary. The next section is the uncertified part of the new reporter's record. On December 13th, 1999, another hearing was conducted regarding the discovery that Simmons did not prepare a new record of the pretrial proceedings that were reported in volumes 10 and 11 of Halsey's record. Simmons was instructed to review both volumes and certify a new record of those proceedings if she could. On January 28, 2000, Simmons testified about her review of volumes 10 and 11. Simmons prepared a new certified record of the proceedings reported in volume 11 and the proceedings on the afternoon of October 21st, 1996, that was reported in volume 10 by using the same procedures that she used to create the other parts of her new record. Simmons would not certify a new record of the proceeding from the morning of October 21st, 1996, that was reported in volume 10 of the Halsey record. Simmons testified that she did not receive an audio tape of the proceeding that was conducted on the morning of October 21st, 1996. And this was the reason she refused to certify this portion. Quote, "Based on the 10,000 pages that I've done previous to this, and seeing Miss Halsey's record compared to her notes and the audio tape, I don't feel comfortable certifying to the first 53 pages without an audio tape to listen to," unquote. In Simmons' opinion, Halsey must have used an audio tape to edit that part of her record because the hard copy was different than her paper stenographic notes. Simmons physically included an English translation of Halsey's paper stenographic notes of the proceeding on the morning of October 21st, 1996, in volume 10 in her own record, but her certificate in that volume specifically excludes those 54 pages. On February 4th, 2000, Halsey's attorney informed the trial court that she did not have an audio tape of the proceedings for the morning of October 21st, 1996. Halsey's lawyer did not indicate whether she made a tape and lost or destroyed it. On February 9th, 2000, the trial court issued an order that adopted Simmons' testimony about the pages in her record that she did not certify. The trial court did not decide whether the uncertified 54-page transcript of Halsey's stenographic notes of those proceedings in Volume 10 of the Simmons record conformed to what happened at the trial, or whether there ever existed an audio tape for these 54 pages. Again, however, the only testimony in this record on this subject is that of Simmons, who stated that, in her opinion, there had been an audio tape used in the preparation of this part of the proceedings. Okay, let's just recap, but just a little bit, because I know that this kind of just tends to go over the same kind of information in each section. But this one is very interesting in particular because Simmons says, if you remember, they're talking about this date of October 21st, 1996. And this is the day, well, first of all, that jury selection for the trial began, number one, but number two, that this is also the day that Mulder requested that he become Darlie's attorney. And this is the day where, at this point, he's representing Darlie's mother, Darlie Key, as well as her husband, Darren, and whether or not it's a conflict of interest. The whole time, Halsey has says, "Hey, I don't have a recording of this, so I can't make an official record of this." But Simmons, the one who went in to try and fix everything that she could, truly believes that in order to edit that particular testimony on October 21st of 1996, she believed that Halsey did use an audio tape to edit that part because the hard copy differed from the paper notes. But Simmons wouldn't certify this new record because she did not have an audio recording, yet she believed that Halsey actually did, just based on what she saw. But somewhere it's nowhere to be found. Nobody knows where this audio recording is. Now, there is a citation here. This is citation number 25. And here's what this says. Quote, "Appellant objected that Halsey's certificates on the original record could not be used to certify any part of the new one because she testified at her license revocation hearing that she knew her record was inaccurate when she signed them." Now, the trial court did not rule on that objection, but Halsey's certificates were not included in any of the volumes of the new record. Unquote. So next, we're going to move on to the appellant's objections to the new reporter's record and a request for a hearing. In its order dated February 9th, 2000, the trial court extended the deadline until March 6th, 2000 for appellant to file objections to the Simmons record and request a hearing on them. On March 2nd, 2000, appellant filed written objections to the Simmons record and a separate motion for a hearing. Both pleadings also were submitted to this court by a letter to the clerk dated March 8th, 2000. Appellant's motion for an evidentiary hearing identified 27 specific disputed factual questions about the new record. Appellant's 9 objections to the new record were presented in a detailed 28-page pleading. There was a point hearing, statement of facts, and arguments and authorities for each objection. Her objections challenged virtually all of the substantive changes that Simmons made in the record, the loss or destruction of specific parts of the record, the procedures that Simmons used to create her record, and the use of Halsey's certificates on the old record to certify any part of the new record that Simmons would not certify. She promised to introduce an English translation of Halsey's original stenographic notes to prove her objection that Simmons used the unauthenticated audio tapes to make thousands of inaccurate substantive changes in the record. Numerous exhibits were attached to the appellant's objections to the new reporter's record to substantiate her allegations about facts that were not in the record of the previous proceedings that the trial court conducted. Appellant's exhibits included statements that Halsey made at a hearing to revoke her license and to the press after she invoked her Fifth Amendment right not to testify in this case. These included Halsey's concession that there could be something wrong with her own audio tapes and she would not depend on them. Halsey warned that her audio tapes should not be used to create a record because they could be blipped. Halsey confessed that she knew that her record was inaccurate when it was filed. Halsey admitted that she lied to the trial court to try to conceal defects in her record because she did not want Appellant to get a new trial. Among other things, she blamed this court's, quote, threatening me with jail, unquote, as why she filed her record knowing it was inaccurate. The trial court had previously stated it was, quote unquote, quite troubled by the fact that a witness might, quote, invoke her Fifth Amendment right not to testify here in court and then give their opinions to the press, attempting to influence public opinion. Because this is not a game. There are definitely 2 children who are dead and a woman who's been sentenced to death, unquote. Attached to these written objections were 42 pages of exhibits supporting that pleading. In its order of September 7th, 2000, the trial court found that Appellant's, quote, objections are clear, concise, and sufficiently apprise this court and will apprise the Court of Criminal Appeals as to Appellant's objections, unquote. The trial court further found Appellant, quote, adequately preserved her objections for review, unquote. Of course, what Appellant was seeking went beyond a mere understanding of her objections. Appellant was seeking a ruling on these objections in a proceeding which comports with due process by permitting testimony, evidence, and argument. In Exhibit E of the written objections, there are listings of multiple substantive changes Simmons made in Halsey's reporting of nonverbal responses, among other things. For instance, during voir dire, a juror, per Halsey, responded to a question by answering, mm-hmm. However, Simmons revised this to uh-huh, which of course is inconsequential, but then Simmons added the parenthetical, quote, witness nodding head affirmative, unquote. Appellant will assume that Simmons could not hear on the audio tape the juror nodding his head. And since Simmons has testified it was not part of her job to deal with Halsey's parentheticals, just where did this new parenthetical come from? This same scenario is presented in comparing HR.12, and then they give a bunch of other numbers to point out a few. Simmons also changed responses of a juror, apparently based on whether she could hear it on the audio tape. Now, Appellant understands as well as anybody Simmons' refusal to vouch for Halsey's steno notes or reporter's record without audio tape corroboration. But that only amplifies the problems presented by this record reconstruction effort to begin with. Plus, it places the parenthetical issue at the fore. The principle of presumed regularity cannot be applied to Halsey's parentheticals given her history of lying and knowingly submitting an inaccurate record. But coupling this with Simmons' stated refusal to put anything in her record which she could not corroborate leaves all the parentheticals in this case subject to challenge. The next subject in this is the cancellation of the hearing on Appellant's objections to the new reporter's record. The trial court set Appellant's case on the calendar for September 8th, 2000 to conduct a hearing on her objections to the new reporter's record. Appellant served subpoenas for Halsey, Simmons, and 9 other witnesses to testify at the hearing. The trial court also signed Appellant's subpoena for an out-of-state witness who was to be flown from Virginia to Dallas. Appellant filed a motion to suppress the unauthenticated audio tapes. The state acknowledged in its response to the motion that it expected the trial court to conduct the hearing and allow the parties to question Simmons about the new record. The trial court canceled the hearing on the day before it was scheduled to take place with the issuance of its September 7th, 2000 order. The next section is the trial court's response to Appellant's objections to the new reporter's record and request for a hearing. On September 7th, 2000, at 3:15 p.m., the trial court issued a 1.5-page order, which made the following findings. 1. The trial court found that it complied with all the orders that the Court of Criminal Appeals issued before appellant filed her objections to the new reporter's record. 2. All of the prior findings and orders previously issued by the trial court before appellant filed her objections to the new record were incorporated without making any findings of fact or conclusions of law about those objections. 3. Appellant's written objections to the new reporter's record and motion for a hearing adequately preserved all of her claims because any tribunal would be able to discern the basis for them. 4. An additional evidentiary hearing is not necessary to comply with the orders of the Court of Criminal Appeals that were issued before appellant filed her objections to the new record. And 5. No additional evidentiary hearings shall be conducted by the trial court unless the Court of Criminal Appeals instructs otherwise. And in this section, there is another citation, citation number 28, which says the docket sheet does not show that a hearing was scheduled on September 8th, 2000, but appellant filed a formal bill of exception to make a record of that fact. The trial court subsequently ruled that it did not have jurisdiction to approve her formal bill. The state will not dispute that a hearing was set as alleged. Of Texas 34.6, and the error was not harmless. Okay, so this was a really long set of sections, and normally I would have broken it up to explain each one, but it just kind of goes over the same information that we've already heard about. However, the one thing that really stood out to me, and I'm sure it stood out to you if you listened to this entire thing, and if you did, thank you. This has not been an easy reading. I'm beginning to question whether or not I should have done this one, but I've started, so I'm going to finish. And the thing that really stuck out to me was, I believe we are under, yes, it's the appellant's objections to the new reporter's record and a request for a hearing. In here, they talk about during Halsey's trial, I guess you'd call it a trial, where they went over her notes to determine whether or not they could be certified because there were so many, problems with it. Evidently, she admitted that she had lied to the trial court to try to conceal the defects in her record because she didn't want Darlie to get a new trial. So that really stuck out to me as something like, what? Wait a minute. What is going on here? I mean, why would a court reporter try and do this and try and alter maybe her records? Because she, instead of being the impartial party that she should have been because she's the court reporter, she actually said she lied to conceal these defects because she didn't want Darlie to have a new trial. So anyway, that just struck me as like, holy cow, are you kidding me? I mean, yeah. So anyhow, I know this has been incredibly long, and I apologize for that. I'm trying to get through this direct appeal as quickly as I can so we can get on to the other shorter versions with the defense response and the state's response, and then finally the ruling on the appeal. So until then, I probably have a couple of more to do in the direct appeal after this, a couple of more episodes. But I do want to thank you all for hanging in there with these. It is so much appreciated. Believe me, it does not go unnoticed. So thank you. Thank you all for listening. If you haven't yet, please subscribe, especially if you find yourself coming back time and time again. It helps the page so much, especially in YouTube. If you listen and or watch on YouTube, and click the like button, that helps as well. So again, thank you all so much. We will talk very, very soon. Bye for now.